going to be talking about who's going to be your decision maker. Someone's going to make financial decisions or healthcare decisions, and also upon your passing away, where do you want your assets to go? So to start with, I wanted to, first of all, bring up, we call this a design essentials. So this form here that we're looking at right now, it's a form that's sent out to the clients in advance of the first meeting with the attorney when they sit down for a composition. And the idea is to have the clients think about this prior to coming to the office. So when they do come to the office, they thought about this in advance, and then the attorney can kind of guide them through the process, making sure they're naming the right people that they want to choose, but get them to think about prior to that meeting. So the first section is financial decisions. We'll talk about this in more details in the PowerPoint, but you want to think about who's going to make your financial decisions if you can't do that. So typically, if it's a married couple, husband and wife are going to be first on the list for each other. But then after that, then you got to think about who are your backup agents for that as well. Again, we'll talk about that some more in another minute or two. Same thing for medical decisions. If you're competent, you make your own medical decisions, but if you're not competent, who's going to be your backups? If you're a married couple, it's quite often going to be the spouse first. After that, you've got to figure out who you want to make those decisions. And then if you have minor children, then we're going to have a will that's going to nominate a guardian conservator. We'll talk about that more in a minute as well, but the guardian is going to make the day-to-day decisions, and the conservator is going to make those financial decisions. That's assuming that both parents have deceased. So you need to name those individuals in your will, because the probate court, if you don't nominate those individuals, the probate court's going to figure out who you want. Well, if you don't give them some names in the order you want them in, they may pick someone that you don't want. So we'll talk about that. And then the fourth topic we're going to talk about is the distribution. So when you pass away, where do you want your assets to go? Does it go to a spouse? Does it go to kids? Does it go to charities? So a lot of those things we'll talk about in some more detail. So I just want to show you this 3-page PDF file that we have, and we sent that out to the clients prior to their coming to the office, so they have a chance to think about these topics before they actually show up in the office. And it gives them a chance, if they want to, maybe they're going to talk to their kids, make sure all the kids want to act as an agent. So with that, let's start our PowerPoint and go on to the first slide. So 3 agents that we start listing on that design essentials. Financial decision makers, that's number 1. Second is medical decision makers. And third is guardian conservators. That's only if you have minor children. If all your kids are over 18, you don't need to nominate guardians and conservators. But if you have kids under 18, that's when you want to nominate those. So let's talk about financial. Well, let me go first on to the financial decision makers. This slide right here. Trustees in your trust. The trustee makes your financial decisions inside of a trust. When you nominate someone to make financial decisions in the will, they're called a personal representative. And in the financial power of attorney document, they're called attorneys in fact. So a trust is a legal entity, and that entity can own your stuff. They can own your house, they can own your bank accounts, it can be beneficiaries on some things such as IRAs and 401ks, but a trust can be a legal entity that actually owns, has the ownership over a bank account, checking account, savings, real estate, things like that. The trustee, that's the person inside the trust that manages the assets. So when you nominate a trustee, it's typically the grantor, the person that creates the trust is the grantor. They're often the trustee to begin with. But if that person becomes incompetent or passes away, we name successor trustees at that point. So quite often, if it's a married couple, both husband and wife are the grantors, they both create the trust. And also both those individuals, husband and wife, are the trustees. So that gives full control over those assets to the husband and wife that created the trust. But if you both can't act, or if you're a single person and the single person that starts off as a trustee later on either passes away or becomes incompetent, we name successor trustees in the trust. and we like to have 3 people in that trust generally. So if you name one person and that person says, I don't want to do it later on, they're too busy at work, raising kids themselves, pass away, whatever reason they decline to act in the future, we want some backups. We want to make sure that this trust has a minimal amount of changes needed in the future. And when you start adding successor trustees, now you've kind of put in some redundancy. So if the first person or second person can't act, you've got backups after that. The person representative, that's the person in your will. The old term was called executor of the will, but the current term that's used right now is the person representative, and that's also a financial person that you name when you fill out that form, that design essentials. And then there's another document we draft called a financial power of attorney document. In the financial power of attorney document, that person is called attorney in fact. Now, it's pretty common for people to be walking to the bank, and at that point, the bank says, okay, who are you here for? Well, I'm POA for mom, or I'm POA for dad. What they're saying is that I'm power of attorney for mom or power of attorney for dad. So that's a pretty common nickname, but the legal document itself will define that person that's acting in that financial capacity as the attorney in fact. But that people often say, I'm just power of attorney for mom or dad. That's pretty common. And that financial power of attorney documents used for things outside of the trust. So apply for government benefits, file tax returns. They may be cashing a check that's made payable to that individual that can't sign their name. So the attorney in fact can be made so it's effective upon your disability, or can be made effective immediately. Most of the time we draft those effective immediately, and that avoids the situation where if you're not competent in the future, that next agent in line doesn't have to find 2 doctors to say that you're not competent. So long as you trust that first person on your agents list, we usually name those agents as the attorney in fact and have it effective immediately at that point. Some people, as Chris kind of mentioned at the beginning of the topic here today, some people choose their kids in age order. That's not necessarily the best choice. Just because a person's the oldest doesn't mean they're oldest and the wisest, doesn't mean they're going to follow your wishes. So think about other things, other factors that would come into play besides age order when you start naming agents on your list. Doesn't have to be your children, but most of the time, if you have kids, that's usually the first people that the parents pick. And it kind of depends on the age of the kids as well. So factors to consider when choosing someone to make financial decisions would include who's best at managing funds, your money. Sometimes it's one of the kids that they may have a banking background, a financial advisor background, someone that's just experienced with money, know how to invest it. They're going to spend your money based upon your values, not theirs. Someone that has the time to help. So it could be someone that's close by. So proximity, location could be a factor, but don't pick someone just because they live next door to you or they live in the same town, but it's going to be easier. But that's not the final decision, I would say, to choose someone. So pick someone that's going to make sure that you're going to have the time to look at for your best interest, maybe someone that's detail orientated, someone that's good at managing funds, that they can manage their own funds, and that they're going to do a good job on your behalf. So it could be your kids, doesn't have to be, but that's the most common. Other people you may think about naming could be your siblings. The concern was you start naming siblings. If you're in your 70s or 80s and your siblings are the same age, a couple years older or younger, I'm going to say pick a longer list. You can still name them if you think they're the best choice. But if you start naming people close to your age bracket, if you become incompetent, think about the fact that your sibling that's 2 years older or younger, they may have health issues and may decline to act. So you're going to want a longer list and hopefully have at least a couple people that are 10 or 20 years younger than you are. We'd like to name 3 people as successor agents. They act one at a time. And the idea is to have backups, because the first person you name in 10 or 20 years from now, they may not be able to do that. They may be too busy with their own kids. They could be moved away. They could have health issues themselves. So we like to have successor agents that we name in there, those documents, and they would act one at a time. If the person says, yes, I can do that, we stop right there. If that first person says, no, I can't do that anymore, then we go on to the next person. That avoids us having to go back and redraft the documents, so it can save time and expense later on. So we like to have successor agents for that reason. Some parents have 4 or 5 kids, and sometimes they'll name all kids just so someone doesn't feel left out. That's fine too, if you think all 4 or 5 kids are a good choice. So you don't have to name them all, but we'd like to start with at least 3 different people. And if there are 4 kids involved, you can name them all if you want. Keep in mind that not all kids want to act. Sometimes those kids are happy they don't have to act. Specific example, I've talked to many families and they say, my son or daughter, they're too emotional. They wouldn't follow my wishes. They won't pull the plug. And so they don't put them on that healthcare power of attorney document because they know that person can't make that difficult decision and wouldn't follow the wishes of the parents when the time came that they may have to make that difficult decision. So we just talked primarily about financial decisions, looking at your healthcare, looking at your financial power of attorney document, your trust, and your will. Next up is a medical decision maker. So who's going to take care of your medical decisions if you can't do that? So the healthcare power of attorney document in Michigan, that's only effective on disability. That requires 2 doctors certifying you as not being competent. Then you name patient advocates to make that decision. So besides the medical decisions documents we have, besides a healthcare power of attorney for that, we also have a HIPAA, pretty standard HIPAA, and then a funeral representative designation, and we have a disability panel in the trust. So let's talk about those one at a time. The healthcare POA document. So you name patient advocates. We like to have 3 of those. 1 person acts at a time. As I mentioned earlier, you make your own decisions as long as you're competent. The doctor wants to talk to you as the patient. They don't want to talk to the other kids and say, what do you want to do? You can have them in the room if you want, but the doctor has to hear from you if you're competent. It's got to be your own decisions, what you want. But you can have other kids, other family members having input if you want as well. That's the healthcare power of attorney document. Also, when we draft our healthcare power of attorney document, we have what they call mental health powers. So when the law changed about 4 or 5 years ago, we put in what they call mental health powers. And if it's not in that healthcare power of attorney document, and I've seen ones that are drafted recently that don't have them in there from other places, you could be in probate court if you need those types of treatment. So I know some of our clients have been to Pine Rest, and the doctors there have looked at our documents and said, yep, that's fine. You've got those healthcare power of attorney documents in place. So that person didn't need to go through probate court, didn't need a guardianship because the healthcare POA that we drafted had the powers in there and drafted according to the statute. So it's very important to have the proper healthcare power of attorney document in place. And those have to be signed while you're still competent. Next on the list is a HIPAA. So basic HIPAA form. We draft it so you name who's going to contact the doctors. They can get medical records. They can talk to the doctors. They can review the records. Even if you're competent, you still can name someone to talk to the doctors. And the HIPAA form that we have drafted, that can be used at any facility. So a lot of times, each of the doctors have their own form, but if you're out of town, go to the emergency room and you want to have a family member, your first agent to talk to the doctors, and you're not able to do that, you're unconscious, for example, in ER, you can have a HIPAA form that's already been signed in advance, and that person can then talk to the doctors to get the medical records or whatever they need at that point in time. The next thing on that list, the funeral representative designation. So the same people that make your healthcare decisions can also make your funeral arrangements. So we figure if you choose that person to make serious decisions, surgery, no surgery, chemo treatment, no chemo treatment, DNR, no DNR. That's probably the same list that you want to use for your funeral representative designation. Now, it's pretty easy for the spouse to make funeral arrangements because the funeral home will talk to the spouse at that point. But when it goes to the kids, a lot of times they're going to say, we want this in writing and we want to see which one that you've named. So we draft this document. If you don't have that funeral representative designation document and the spouse is not alive to make that decision and you're a single person at that point, that's when they want all the closest relatives to sign off on that. And that can be difficult, especially if the kids and relatives are at a distance or they don't agree. And if they don't agree, now you run the risk of going back to probate court because you need someone to make that decision. And especially if someone has cremation, that's especially when you're going to see funeral homes push back and say, we want something in writing. Who's going to make this decision? Or if it's 3 kids that are alive, they want all 3 kids to agree to this. So we draft this document to avoid that problem in the future. That also raises a topic that slipped my mind. So on a healthcare power of attorney document, you name who's going to make your healthcare decisions. Just because you're married doesn't mean your spouse has that right automatically. Now, if you go to a emergency room, quite often the doctors are going to talk to a spouse at that point or talk to the parent. But on a long-term basis, you need a healthcare power of attorney document. Just because you're married or just because you're the parent of a 20-year-old doesn't mean you can make healthcare decisions. So anyone over the age of 18 really should have a healthcare power of attorney document in place. Just because you can't guarantee on a long-term basis the doctors are going to talk to you. Just because you're the parent or the spouse doesn't mean they're going to talk to you. Maybe in an emergency situation until you get something in place, they'll do that, but not on a long-term basis. Number 4, we use that lineup that we talked about for the medical. Use that as a disability panel in your trust. So you're going to be named as a trustee generally of your trust. You're going to be having powers to handle the trust assets if you're the grantor, and then you have successor agents after that. But as long as you're competent, you make all your own financial decisions and you manage your trust assets. Well, if you're not competent, we've got to have someone that's going to determine that you're not competent to remove you as a trustee. So what we do is we set up a disability panel, and the same people that on your healthcare power of attorney document are also on that disability panel. And now majority votes, and the majority can remove you as a trustee. So if you're standing on the street corner passing out $1,000 bills, and that's not like you, and the kid says, that's not like Dad, you know, he doesn't have the funds to passing out money like that, they can vote majority votes and they can remove you as a trustee of your trust. And they can do that without taking you to a couple doctors. Because typically people with dementia are in denial and they don't need to see doctors because if you ask them, they'll tell you they're just fine. So we use a disability panel to avoid that situation where you have to take that person to a couple doctors. Guardian conservators. If you have minor children, those under the age of 18, we need to nominate in your will a guardian conservator. The guardian is the person that's going to make day-to-day decisions for that minor, and the conservator would manage the finances. Now, as long as one of the parents alive, the parent's going to be acting. But if both parents are deceased, then we're going to turn to the will, and that will is going to nominate both the guardian conservator. Now, the judge is going to look at that list, and they'll find out, is this person suitable to manage these assets and to be the guardian as well? And they'll do a background check. You know, they'll make sure the person's still suitable, but generally they're going to follow your wishes. And if you don't have your wishes spelled out, the judge won't know what you want. You may have 2 brothers and a sister, and you didn't want your sister to act as a guardian, but the judge won't know that unless you put that in writing. So if you got minor kids, you want to make sure you have a will and make sure your will outlines your guardians and conservators. Topic number 4, distribution plan. So upon your passing away, where do you want your assets to go? Could be checking accounts, savings accounts, real estate, retirement accounts, tangible personal property. So books, jewelry, china, coin collection, just things you have around the house, that would be tangible personal property. You've got to think about, where do those assets go? Does it all go to one person? Does it all go to the surviving spouse? Does it go to the kids equally? Does it go to some kids and not others? You got to think about who's going to take under your plan. How do they take? We set up trust generally if the person's less than 30 years old. Depends on the size of the assets. If there's $100,000, generally don't give $100,000 to a kid that's 21 years old. If you're 70 years old and you've passed away and you've got some kids or grandkids that are under the age of 30, we're going to start looking at, okay, how old are they? Can they handle the sum of money? And generally, we're going to put someone else in charge of that. So default language is, if a beneficiary is less than 30, they're not going to manage their funds. When they're 30 to 40, they're going to be a co-trustee. And when they're 40 and above, that's when they're going to be a trustee, or they can with someone else, or they're going to say, just give me the pillowcase of cash and put my check account. So we'll talk about that in more details at one of their meetings in person, but we do separate share trust for the beneficiaries to protect the assets, and don't give someone that's too young, that never managed $200,000 before, that's 20 years old. They'll have a tendency to spend it pretty quickly. They'll spend it quicker than you can earn it generally. So things to think about when you do the distribution plan is who gets it, how they get it, when they get it. If you do give a specific bequest, maybe it's considering dollar amounts or percentages. So if you want to leave a dollar amount to someone, maybe it's $5,000, maybe it's $50,000. Depends on the size of your estate. A lot of times people want to give some smaller sums to individuals, but they don't want to leave $50,000 to one person if when they pass away, their estate's worth $200,000. They only leave 25% to that one person. So that's when we do the lesser of two figures. Could be a dollar sum and a percentage of their estate. So for example, it could be $50,000 or 10% of their estate. So we start thinking about that to making sure that if they want to leave something to that person, but they don't know how much they're going to have when they pass away, they could have another 20 years to live. They don't know what their estate's going to be worth when they die. They want most of their assets to go to their kids. So they'll give a smaller amount to some other individual. And that's when they do the lesser of two figures, percentage and the dollar amount. The other thing to consider too is if you leave it to an individual and that person passes away, who's going to receive those assets? Does it go to that person's children? Does it go to someone else? Does it just lapse and go on to the residual beneficiaries, those that receive all the assets that are not specified in our specific bequest? So think about alternates, that if the person is not around when you want to leave them assets, and they pass away before you do, where does that person's share go? Other things to think about too, some people will leave assets to their son-in-law or daughter-in-law. Most of the time, our clients will say, give the money to my kids, and if they predecease, then give it to their children or give it to their siblings. Sometimes clients will want to leave something to their son-in-law or daughter-in-law. If we do that, then there's three things we usually add to those conditions. Number one, at the time, we'll pick on your son. At the time your son passed away, at that point in time, was there any divorce proceedings pending between him and his wife at that point? If there was, then that daughter-in-law would not receive any of the assets under that bequest. Second thing we would look at the time that your son passed away, and then you passed away later on, did that daughter-in-law remarry? If she did, generally people don't want that money going to the new daughter-in-law's family because it's going to be people you've never met before. The other thing we look at, did the daughter-in-law survive you? Because if she didn't, if you give it to her estate may say, give it to my charities, give it to my nieces and nephews. It may give it to people you've never met before. So 3 conditions: if you ever leave it to an in-law, daughter-in-law, or son-in-law, no divorce proceedings pending at the time your son or daughter passed away, that surviving in-law did not remarry, and 2, that in-law did not predecease. So 3 conditions. We want to make sure that the assets go to someone that you know where they're going to go to, and not to someone else that you've never met before. So we put in those 3 conditions. Other things to think about: do you want to leave any money to charities? That's a good time when you're setting up a trust. Do you want to leave most of your assets to your kids? Maybe some of it goes to a charity. You got to think about that and how much you want to leave. Again, that's a good topic when you start talking about the lesser of figures, lesser of a dollar amount or percentage. And then I talked about earlier the separate share trust, ages 30 and 40. So less than 30, the person's not going to have full control. Someone else is going to manage those funds for them. So they still have access to the funds through a trustee that we talked about. And then when they're 40, they've got full control. Another type of a trust we draft for beneficiaries when you pass away is a special needs trust. If your beneficiary, son, daughter, other beneficiary, has special needs, for example, they're on government benefits because they have some health issues. They may be disqualified from those benefits if they have too much money. We give them a special needs trust. It's called a discretionary trust. And that type of a trust will not get that person disqualified from those government benefits. It can also be used for other situations. Some of our clients have children who they've got a lot of gambling debt. You give them too much money, they'll just spend the money on gambling or drug addiction problems. So anytime there's someone who has a special needs, we put someone else in charge of those funds, but the money can still be used for that person's benefit at the discretion of the trustee that you pick. Also, people sometimes want to tell me that they want to leave money for one of the relatives. I want to give it to Sam, and Sam's going to hold it for the benefit of Becky. Well, tell me why you're doing that. You don't want to leave it to Sam because I can't guarantee you Sam's going to outlive you. And if Sam's not alive, who's going to hold the money for Becky? So the better way of doing that depends on the situation, what your intent is. It could be a special needs trust if Becky can't manage the funds, or maybe it's a separate share trust, and when Becky's 40, she can manage the funds. So I don't want to write a general rule, don't leave money in someone else's name and say it's the discretion of Sam. He's going to spend it how he sees fit on Becky's benefit. You can't guarantee that Sam's going to be around, and if Sam's not there, who's going to do it? Well, that's the perfect situation where you do with some type of a separate share trust or special needs trust. Other things we draft in a distribution plan is a kid loan. So kid loan could be a situation where maybe you've loaned your kids money, maybe they need down payment on a house, you paid for their tuition, you gave them money for something else, whatever it happens to be, and you want to treat all your 3 kids equally when you pass away. So we draft what we call a kid loan. And you can fill that in on the form that we have. It's kind of a spreadsheet format that you gave, for example, Mary $10,000 for a down payment of a house. And over time, maybe Mary paid back $2,000. So she still owes you $8,000. So then before Mary receives any money, if you had 2 other kids, the other 2 each get the $8,000 that Mary had in advancement. And then after that, then it gets divided a third, a third, a third. So that's a situation where people plan in advance that I know I gave money to one of the kids, and I want to make sure all 3 kids get treated equally. The other thing to consider when we draft a distribution plan is a pet trust. So a pet trust is set up, you may have some animals, dogs, cats, horses, whatever. You want someone else to manage those pets for you. And the pet trust can specify, am I going to set aside some money for the pet trust? Do you have certain individuals that you want to offer the pets to first? In which order? And you name a pet trustee, and you may specify how much money is going to the person that's going to adopt these pets, because pets can be pretty expensive, and you can put a dollar figure in there, or you can say the discretion of the trustee. You're going to set aside some money, because when you pass away, you don't know how many pets you're going to have, the age of the pets, what the expenses might be. So you may put in a range in there, but at least leave some money, so when someone adopts the pet, they may not have the funds to pay for medical bills and vet bills. So we can draft a pet trust if you have a lot of pets. Other things to think about when you set up a distribution plan is a right to receive. So when you may want to give someone the right to receive, for example, $50,000. And is that in addition to or part of their residuary share? So the residuary share is what's left over after you pay any expenses, after you give any specific bequests out. Then you've got a residuary share. It gets divided among those people who are named in the residuary, and you may give someone else the right to receive a certain sum of money. So it may not be treating all those individuals equally, but I want to give one of my kids an additional sum of money because they helped me through tough times, or they have greater needs, or you just want to treat that person differently for some reason. So we give a right to receive, and we have to know, is that in addition to or part of the residuary share? And also that person doesn't have to be in the residuary, they can have the right to receive money as well. Also, oftentimes people want to draft a right to purchase. So they may want to have one of the kids the right to purchase the cottage or the home. And then we start talking about, okay, if it's a right to receive, is it going to be a right to purchase rather? Is it going to be 2 times the SEV? Is it going to be fair market value? We get to appraisals. Some people want to give a discount to one of the kids. Maybe you're not using a realtor at that point, you want to give them a discount. And if that person can't buy that property outright, they don't have the cash to do that, can't get financing, are you going to give them the option that they can buy it through the trust, and the trust can finance it? So maybe they pay the trust back over a period of 10 years or 15 years. And how is that financed? Is it free from any interest? Things like that. So things of those sorts need to be discussed when we talk about a right to purchase. Specific bequests, we kind of talked about that a little earlier. That's when you say, is it a percentage or a dollar amount? Could be specific items, could be real estate, it could be someone's car, could be some other tangible property, could be paintings, could be any type of item that you want to leave to someone, or dollar amounts. A grandchildren trust. Some people want to leave money for the grandkids, and it may be a pot of money. Let's say it's $50,000 divided among the then living grandchildren. And maybe you leave it in trust until the youngest is 25 so that they can use it for the grandkids. Does not be treated equally at that point. Or you can do a grandchildren trust and say, here's $50,000 divided among my then living grandchildren. They each get their money at that point. And then again, we're going to look at the ages of the kids, the grandkids. If they're under 30, typically, we're not going to give them the money outright, but it depends on how much money it is, and depends on a lot of different circumstances. But we often draft grandchildren trust when the grandparents want to leave some money set aside for their grandkids. It could be a small sum, could be $1,000, just acknowledgement that they love the grandkids. It could be a larger sum if they want to help them out with a down payment on a house, or help with their tuition. Real estate, we've got to talk about that, whether that's part of the residuary share. Is it in addition to the residuary share? If there's a lien on the property, maybe there's no lien right now, but what if there's a lien later on? Maybe you get a HELOC, a line of credit on your home. Is the person going to receive this home free and clear from any liens or mortgages? What's included in that home? Is it all the contents, just appliances? So things we got to talk about when you do set up a distribution plan and you want to leave real estate to somebody, is what does that include? Some last thoughts. So talk to a design attorney, work on that design essentials form. So let me bring that up for just a second. So we've been talking about financial decisions. That's the first topic up here. Those are the people in the trust, the trustees, financial power of attorney document, the person representing the will. Medical decisions, those are used in the healthcare power of attorney document, the HIPAA form we talked about, the funeral representative designation. And then if you have minor kids, then we talk about the conservative guardians, and then we just talked about the distribution plan. So how does that look? So those are the things that you're going to think about when you fill out that form. So when you do talk to a design attorney, it's beneficial to have that design essentials forms figured out in advance. It just makes the meeting smoother and easier. It has people thinking about this before they come to the attorney's office. We also talk about TALT, Tax Advantage Legacy Trust. So during one of the meetings, we can talk about it in some more details. It's kind of beyond the scope of this meeting, but it's a special trust used for IRAs and 401ks. It has some tax benefits. And the other thing to think about is a residence trust. So sometimes it's a blended family, and let's say the wife brought most of the assets to the marriage, including the home. You may want to give a residence trust. So if the wife passes away first, the husband can stay in the home with whatever conditions you want to put in there. And then when the husband passes away, then that residence trust gets terminated and the proceeds can be divided how they want. Could go back to the wife's side of the family, could be divided whatever the husband and wife want to do. But a residence trust is pretty common in a situation when we have a blended family. We also add a cottage trust. If someone has a cottage that they want to keep in the family for generations to come, we draft some of those. That could be a sub-trust of one of our trusts that we draft. So upon your passing away, set up the terms of the cottage trust. Who has a right to use the cottage, the terms of those trustees, what they have to do. Maybe you set aside some money to pay for the cottage for some period of time, pay the taxes and the upkeep. That's a possibility. We also draft a farm trust. Does a farm produce income? So we have to have different language in there for a farm trust than we do for a cottage trust. And if you have a business, we may draft an LLC or a business protection trust as well. We can talk about that in some more detail. So protect those business assets if people have those. That's the only comments I have so far. So if you need to reach me, you've got my email address and phone number up on the screen.